Hey y'all, Rob here with ATX Legal, here with part 5 of the Assault Family Violence Guide for 2023. And in this chapter, I'm going to be talking about the family violence finding. Now, the family violence finding is something that comes along with any conviction that deals with violence against a family member or even a roommate. And it's something that you really don't want on your criminal record because once it's there, there's no way to get rid of it. It's something in the legal world is called a collateral consequence, meaning that it goes along with a conviction. You might be charged with a misdemeanor and look up, Class A misdemeanor, oh, there's up to a year in jail, but then the collateral consequence is listed in a completely different section, and if you weren't paying attention, you might overlook it, but it is there for any family violence case. When does it apply? Only for convictions or for deferred adjudications, and that's pretty important, and I'll talk about that in a little bit. But importantly, it doesn't apply just because you were charged with a crime. If that case is dismissed or if you're acquitted, then that family violence finding does not apply. Now, family violence in general is defined very broadly. So it's not just a dating partner or a wife or a husband. It could also apply to a roommate, other family members, your mom, your dad. It's very, very broad. So if you're convicted of assault against one of those classes, the family violence finding applies. And the judge has no authority to waive it. So there's no way to negotiate with the prosecutor and say, hey, we're going to go ahead and plead guilty to this, but we want the family violence finding to not apply. There's no way to do that within the law. The judge can't do it. The prosecutor can't do it. If you are convicted of one of these cases, the family violence applies, period. And even if you negotiate a plea for a deferred adjudication, you might think the family violence finding doesn't apply here because it's not a conviction, but you would be wrong. Any deferred adjudication, even though there's not technically a conviction there, the family violence finding does apply. Okay, now that we've talked about when the family violence finding, about why it's so bad and why you need to avoid it. Now, first of all, any future family violence charge, no matter how minor it is, even if it's a little scrape, it's going to be up to a felony immediately. That's automatic. It will be enhanced to a third-degree felony. So that next charge would end up in district court. It's going to be much harder to deal with. They're going to look at your criminal history as well and say, you've been convicted before, and we're not going to treat this one so lightly. So that's obviously something you want to avoid. Second, you're not going to be able to own firearms for the rest of your life. Now, you might look at the Texas statute and it says you can't own firearms for 5 years, but there is a corresponding federal statute that actually goes all the way to a lifetime ban. So you would never be able to own firearms for the rest of your life. Even if you're not into firearms now, you might have a need for one later, and that possibility would be foreclosed to you. Third, a family violence finding is going to be a stain on your criminal history, especially in today's political climate. A lot of employers are going to take that very seriously. You might lose a job. You might not be able to rent an apartment. A lot of reasons that you want to keep that family violence finding off of your criminal history. And lastly, the family violence finding is forever. There's no way to get it off your criminal history once it's there. You can't have it expunged. The only way to get it removed would be with a pardon from the governor, and that happens just about never. So it's going to be on your criminal history for life unless the laws change. So how can you avoid having that family violence finding attached? There are only 3 ways. 1 is to get acquitted by a jury. 2 is to get it dismissed before it goes to jury trial. And 3 is to go with a program like FVIP or pretrial diversion, which I do talk about in a separate video. And these cases do also lead to a dismissal. If you get it dismissed through one of these programs, you can avoid that family violence finding. But if you take a conviction, if you plead to a conviction, if you're found guilty at trial, that family violence finding is going to apply and it's going to be on your record for life. And a quick caveat to that is if you can convince the judge and the prosecutor that the person involved was not a family member or was not one of those classes that's considered protected under the family violence statute, you could be convicted of simple assault and avoid that family violence finding. But I would use extreme caution here because a later judge and a later jury could find that that actually involved one of those protected classes. And even if the current judge puts an affirmative finding that there was not family violence, then you could still have that changed by a later judge and jury. So if that's the case, if you're in that situation, the better bet is to work out some kind of plea that gets you to a dismissal rather than having this on the record with no family violence finding that could be overturned later. It's a very weak way to handle it. You don't want to handle it that way. You'd rather get it dismissed. This is all for educational purposes only, not legal advice. If you would like legal advice on your particular case, you can visit us at atx.legal.